We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this Zoom session of the Appeals Court. We will be hearing this case first on Zoom, and then we will be heading into the courtroom for the rest of the list for today. My name is Amy Blake, and I am pleased today to be joined by Justice James Lemire and Justice Rachel Hershfang. We are your panel for this case and the additional 5 cases that are on our list today. The same rules of court apply here on Zoom. That is, each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of your materials, so you might want to just get right into your arguments. With that, I will call 21P667, Charles Markin and Head USA Incorporated, and another. Attorney Muggia, when you're ready.
Good morning, Your Honors. First of all, I would like to thank the court for accommodating my request to appear via Zoom. I had hoped to amble into the appeals court, but unfortunately, with age, we get increasing medical issues. Again,
no worries at all.
And I appreciate opposing counsel's cooperation in this request. I'm going to get right to the point, Your Honor, since I've argued before Your Honors before, and I don't want to waste a lot of time. The core issue for this court's determination is quite simply whether the record establishes the existence of disputed issues of material fact as to whether Mr. Markin, I'm going to refer to Mr. Markin as Charles, whether he authorized his brother, Anthony, I'll refer to Anthony for clarity, to execute a significant document, a liability release on his behalf. As the court is aware, since this is de novo review on a motion for summary judgment, there is really no deference given to the findings by the motion judge. The court looks at the record and makes their own determination as to this key issue, and the key issue being whether there are any disputed material facts. Now,
what did he do about your client's answer at his deposition?
I'm going to get to that, Your Honor, because that is the issue. That is, but before I get to that, there are other facts that bear on that issue, because that statement has to be taken in context. And those undisputed facts are as follows: that prior to the time that Anthony, the brother, rented the skis on behalf of Charles, there was no prior arrangement. In fact, there was no knowledge by Charles that Anthony was going to rent skis on his brother's behalf. This is a fact that was in fact found by the motion judge.
Why does that matter?
Well, I'm going to tell you, Judge. I'm going to get to that. But I just want to bring to the court's attention some other undisputed facts, because you can't take Charles.
Counsel, I just want to remind you, we're asking questions because this is the second time you told me you're going to get to it. I'd like you to answer my question.
Your Honor's question is, why does it matter?
Yes. Why does it matter whether or not he knew his brother was or was not going to get there ahead of him, sign the release, and get the equipment?
It matters because his one deposition statement has to be viewed in context of the entire situation. And more importantly, there's statements in the record that indicate that Anthony did not know that his brother was authorizing him to do any. But let me get to the Your Honor's main point. And the main point really revolves around the motion judge's decision, where he states that Charles's sworn deposition testimony is really conclusive on the issue of authorization. Now, there's a series of questions which precede the two most important questions and answers. It appears that the motion judge's decision rested on this question: had you authorized your brother to do that for you? And Charles's answer is yes. That question and answer is preceded by a series of questions proposed to Charles, starting with, did you fill out any paperwork at the shop of Wachusett? To which he replies, no, sir. Did you enter anything electronically? To which he applies, no, sir. And then the next important question: had your brother done that for you? Yes, sir. And then he answers yes. And then there's a series of questions about, did your brother have your personal information? Yes, yes, yes. So the prior questions, prior to the paramount question about authorization, really define what the nature and scope Anthony was authorizing. And to determine that, we have to focus on what does that mean? And what that means is when Charles says he authorized his brother to do that for you, well, he authorized him to rent skis.
Well, I mean, counsel, I'm sorry to interrupt, but I'm looking at, I trust the same thing you're looking at, which is page 42 of your client's deposition, which is at page 14 of the
Yes, Your Honor.
supplemental record appendix. And being as fond as the next person of wrestling with questions of grammar, including the indefinite antecedent problem, I think that when you read those questions, there is, did you fill out any paperwork in the shop at Wachusett? No, sir. Did you enter anything electronically? No, sir. On a pad, which I assume was an iPad or anything? No, sir. Had your brother done that for you? Yes, sir. Had you authorized your brother to do that for you? Why does the that in that question on line 24 not refer back to the immediately preceding thing, which is filling out paperwork and entering something electronically? That's how English generally works.
Well, the issue, as I see it, Your Honor, and again, first of all, what we're dealing with is a third-party waiver of very, very significant rights. And there is nothing in the record that unequivocally establishes that the reference to that refers to a release of liability. At his deposition, he was not asked by counsel, did you agree specifically that Anthony was authorized to execute a liability waiver? That is the question.
Well, I mean, with all due respect, I don't think that needs to be the question, because it's pretty clear from the record before us that there was no prior discussion between the brothers, right? They were supposed to get there at 8. Your client was late. His brother was crabby, wanted to get on the mountain, figured I'll just advance the ball so that we can have our full day of skiing, rented the stuff. I think the more interesting question legally is what else, if anything, would have been required for your client to have implied consent afterward, right? So he shows up, he being your client, he shows up, he takes the skis, he puts on the boots, he clips into the bindings, he presumably makes use of whatever pass has been purchased for the day, and he goes skiing. Why is that not implied consent?
Well, what I would, with all due respect, I think that dovetails into the issue of apparent authority. Or do those actions ratify the conduct by his brother? Now, an important fact, which I think the court needs to hear about, is Charles's deposition testimony when he is specifically asked, did you understand that the rental of ski equipment at Wachusett involved agreeing to some type of liability release? To which he answers no. That's then followed up by a question.
What about our case law that goes back decades that says that that's not a defense?
I'm not suggesting that not reading the release is a defense. That's not what I'm arguing, Your Honor. What I'm saying is his statement that he did not understand that he would have to sign a release is quite consistent with his lack of knowledge and lack of ratification.
But isn't that your viewpoint is then inconsistent with his deposition testimony about prior occasions where he skied and signed a release?
I would suggest to Your Honors that what happens at other mountains is not relevant to the specific policies and procedures at Wachusett, which he says he is not aware of because he had never. Did your
client complete an errata sheet?
Did he make changes to his deposition?
Yes.
The answer is no, Your Honor. Again, he said what he said, and again, those two lines of the deposition really are the core issue in this case.
What do you think about your sister's motion to strike where she suggests that you are trying to get materials before us that were not before the lower court?
Well, in my opposition to her motion to strike, I attached to my motion my 9A letters with the understanding that the complete deposition transcripts were part of the record. And as I review this, there's really only one relevant part that should be part of the record, and that's Anthony's deposition testimony, where he states that he was specifically not authorized by Charles to do anything on his behalf because Charles didn't even know he was there. I think there's two lines that are relevant to that issue, Your Honor. And that relates to what Anthony understood the scope of authority was. But let me address your Honor's comments on what I would argue is this issue of apparent authority. And I'm going to refer to the defendant as Wachusett, although named as head. On the issue of apparent authority, I would argue that there is clearly disputed facts as to whether Charles' conduct, i.e., his use of the rental equipment, manifested a ratification of Anthony's prior actions. Although he used the skis, considering that he said under oath that he did not know use of skis and rental of skis at Wachusett specifically required the execution of a liability release, how could he ratify something he didn't know about? So his conduct in using the skis is not a ratification, since he didn't know about this release issue until Wachusett filed their motion papers. I carefully read.
Can I just interrupt to ask one factual question? And if I missed this in the record, I apologize. Does the record before us contain any images of the lift ticket?
I want to say I believe so, but in all candidness, I cannot point that out to a page in the record appendix for Your Honor.
Okay, thank you.
I think Your Honor is probably referring to the very fine print we see on the back of lift tickets which cites the Massachusetts skier statute and similar to
Well-
what would be on a Red Sox ticket.
Yes, I must confess, I've never read it, but I know there's a lot of tiny letters back there.
Yes, but and I don't think Wachusett is resting their case on anything on the lift ticket. I think their case is predicated specifically on the electronic documents executed by the brother.
Before you run out of time, could I have you just address on the spoliation issue? It's clear the judge made no ruling on it, correct?
I believe my understanding as I read his decision is that since he found that the release barred the claim, he did not address it.
But you want us to address it, and as a consequence of what you call the spoliation, reinstate the complaint. Is that the way I understand your argument?
The judge could have addressed the spoliation issue, and if he found spoliation as a sanction, which I requested, one of the sanctions could have been to deny the motion for summary judgment. So what I argued in my papers was his denial or failure to address it is in essence an abuse of discretion, and this court has the power to review that under an abuse of discretion standard.
And I think we're going to go ahead, Justice. We have to, if you have additional questions.
The name of the mountain is Wachusett. There's no S on the end of it. It's Wachusett.
Every time I type it, Your Honor, I make that it's Wachusett.
I'm a Worcester-based judge, and it's Wachusett.
I've never skied there, but I make the same mistake, and my computer tells me there's no S. I see my time is up, and I again thank your honors for the time, and I appreciate everyone accommodating my request. Thank you again, judges.
Absolutely. Attorney Bodnar. Attorney Bodnar, it looks like you're still muted. Let's try again. Go ahead.
Good morning. May it please the court, Lauren Bodnar on behalf of Wachusett Mountain Ski Area and Wachusett Mountain Associates. This appeal fails first and foremost for the reasons your honors have recognized, which is that the appellant admitted that he authorized his brother to execute the rental agreement. His brother did in fact execute the rental agreement, which contained a release, and that release is valid and enforceable as to the appellant. His arguments on appeal that attempt to overcome his sworn testimony cannot stand. Second, the appeal also fails because appellant's conduct, as well as his brother's, evidence and support the agency relationship. In addition to the admission, appellant went to the ski area. His brother had rented or started the rental process for him. He accepted the boots that his brother had rented on his behalf, went to the ticket counter, obtained the skis, and he began skiing for the day. At no point did Mr. Markin, the appellant, or his brother attempt to repudiate or dispute that relationship existed, that there was authorization on the appellant's part for his brother to rent the skis on his behalf. And so that conduct also supports that an agency relationship existed on the day in question. And third and finally, the appellant's attempts to distinguish the facts of this case from other cases involving a liability release that is incidental to a transaction fail. This case, there's nothing remarkable about the facts of this case. The Hoffer case makes clear that it's very common for family, friends, co-workers to execute a consumer release on the behalf of someone else, and those releases are valid and enforceable because they're incidental to those transactions.
What do you
Okay,
say
yeah.
about
Here.
your brother's response to your motion to strike in terms of the materials that you say were not before Judge Pasquale?
So the transcript of Mr. Markin's brother was not before the motion judge. Even if it had been, that testimony cannot overcome Allen's admission that he did in fact authorize his brother to rent the skis for him. And it cannot change the conduct of both the principal and the agent in this case. There are cases that make clear that if an agent is to repudiate, they must do so promptly, not in a deposition several years later. So even if that testimony had been in the record before the motion judge, it would not have altered the outcome because it would not have created a triable issue of fact.
So even though the plaintiff admitted he authorized his brother to say enter into the rental agreement, the issue of the release is like a step away. So he authorized the rental agreement, not necessarily knowing there was a release. Doesn't that at least raise an issue that the jury should be able to decide whether or not there's a question of fact here as to his knowledge of the release? It's not cut and dry, the fact that he's rented someplace else and there was releases. He didn't acknowledge that he authorized his brother to sign a release, just an agreement to get some boots and skis. There's a number of cases that say on summary judgment, you just need a toehold. You just need a little bit to get it to the jury beyond the summary judgment stage. Why doesn't this issue of the release come into play where there's no direct testimony that he authorized the release?
Well, Your Honor, first, in addition to plaintiff's appellant's testimony that he authorized the rental agreement, he also testified, and this is undisputed in the record, that he expected to have to enter into a liability release that was similar to the ones that he had entered into before at other mountain resorts. So he did expect it. And there are also cases, including ones that appellant cites, Chung versus Student City, which is a District of Massachusetts case interpreting Massachusetts law, of course, and Hoffer versus Gap, which both find that a release of this nature is incidental to the transaction. So in the Student City case, that was a release that Expedia.com required. I'm mixing these up. Hoffer versus Gap, Expedia.com required a release on behalf of Expedia that it was not liable for any injuries in the course of the commerce travel. And it was accepted that that sort of a release is incidental to the transaction itself. Similarly, Student City, that was another travel case where the judge determined that those types of releases are really incidental to the transaction. And there is also a Massachusetts Appellate Division case, which of course is not binding on this court, that has very similar facts here. Involved it's Webb versus Jiminy Peak, where a parent executed a release on behalf of her child, and that release was found to be valid and enforceable as to the skier who was injured. So there is authority.
Isn't the parent-child relationship very different from a legal perspective from this sibling relationship between two adult siblings?
It is different, Your Honor, in the sense that there wasn't really a question of authorization in that case. Here we have an admission of authorization as well, so I don't think that that difference is meaningful in terms of the outcome of this case, and the trial judge rightfully decided that that admission barred the plaintiff's claims. If there are no further questions from the court, I'll rest on my brief.
Just check with the panel. Seeing none, we will take the rest of your arguments on your brief. Counsel, I want to thank you both very much. These arguments were quite helpful. We're now going to end the Zoom session and head into